So I think that Hulk Hogan does in fact have a fairly strong case for invasion of privacy. The U.S. Supreme Court has never decided exactly at what point the right to privacy trumps freedom of the press. And it suggested, in fact, that there is some sort of limitation. And because of that, Gawker didn't necessarily have the right to publish whatever it found was newsworthy. And so where that line is drawn, we're not certain of today. There are cases that help Hulk Hogan. One of them is a Supreme Court case, the Bartnicki case. And that case was decided 6-3 in favor of freedom of the press. But in that case, freedom to decide what is newsworthy, in effect, in that case, what happened was that two of the justices concurred. And in that concurring opinion, those two justices suggest that a sex tape featuring a celebrity is never newsworthy. And so therefore, if you add those two concurring justices' opinions to the three dissenting opinions in Bartnicki, that means that 5-4, it sounds like the U.S. Supreme Court would have been in favor of Hulk Hogan's privacy and against Gawker's freedom of the press to publish that sex tape. One of the interesting legacies of the Hulk Hogan sex tape case is a case involving ESPN and a New York Giants player, Jason Pierre Paul. What happened in that case is that Jason Pierre Paul had a fireworks accident, and one of his fingers had to be amputated. ESPN knew that Jason Pierre Paul was in the hospital, and so got from someone the medical record proving that in fact Jason Pierre Paul's finger had been amputated. And so ESPN then tweeted out both that the amputation had taken place and a copy of that medical record of Jason Pierre Paul's. He then brought a privacy claim, invasion of privacy, against ESPN. And a court, in a very preliminary case, admittedly, decided that he may, in fact, have a valid claim for invasion of privacy based on the publication of that medical record. The court said that the information about the amputation itself was newsworthy, but that perhaps the publication of that medical chart had gone too far. And that's one of the legacies, then, of the Hulk Hogan case. One of the other invasion of privacy issues that's happening on the internet today is, of course, revenge porn, and so it seems obvious to me that any person whose sex tape or whose nude images have been published by a website or by an individual uploaded to a website should be able to bring an invasion of privacy claim, publication of private facts. This is then the publication of some intimate information, and courts have routinely then upheld the privacy in those sorts of images. So revenge porn cases are related in at least some way to the Hulk Hogan case because there the website published a sex tape, and in the same way then in revenge porn, an individual then uploads nudity or sexual information to the internet. Another very interesting privacy issue involves Section 230. And Section 230 of the Communications Decency Act then protects websites from being liable for information uploaded to them by others. And that's why you have letters to the editor on the NewYorkTimes.com website, for example. The New York Times will not be liable then for those letters to the editor or comments under news stories because of Section 230. Well, Section 230 then also protects revenge porn websites, at least at this moment. If there's a revenge porn website that exists, then if someone uploads a sex tape or nude images to that website, because of Section 230, the website itself is not liable. The people who upload the information to the website will be liable, but the website itself won't be. So it'll be interesting to see if Congress changes Section 230 in years to come, or if courts interpret it in ways that might protect privacy more than the protection of the internet.